Welcome, everyone. It's another Friday. It's another webinar Friday. My name is Rylas Dana from Mott Legal and Dana and Associates. So today is going to be a little bit different. So I started going live in May. So during this crazy times, I wanted to connect more with people, give back to the community, and I guess just kind of share my opinions. So today's show is going to be a little bit different. Last week I was here with Michael Velasco for our live Pro Network show. That's what I call it when I have a guest. So if you didn't see that, go back and watch that last week where I had a guest. Next week I'll be joined by Heather Townsend, who's the financial advisor, for another episode of the live Pro Network. But today what I want to do, I want to talk about some of these new rules that we're going to be seeing in Arizona and give my opinion and my take on it. And when that one of the things that I've wanted to do as far as going live or just having a place to share my voice is just give my opinion on things and feedback. And if you have questions, comments, if you're watching live, leave them there or leave them. I'll check the comments later. I'd love to hear your feedback about these new laws and how it's going to affect things and change things. So let me go ahead and share my screen. I'll move that over there so it's not so crazy looking. So I went to a CLE, continuing legal education, on this topic yesterday by the Maricopa County Bar Association. It was a 2-hour program, really good program. I thought it went fast. There's a lot of information, but I was really interested in this. So after the CLE was over, I went through and read all the materials, most of it, skimmed through all 157 pages to kind of get the gist of it. So what I want to do today is I'll go through some of the highlights of what we're going to be seeing next year and talk about how this is gonna affect things. So the first thing I want to talk about is let's skip down here a little bit. They're calling it, so the ability to own a law firm by non-lawyers. I'm trying to find a good spot in the materials. Let me just take it out of there for a second. Okay, so before you get lost in there and all this material, so when non-attorneys own a law firm, they call that an alternative business structure. So a lot of these new rules are around that alternative business structure and what it takes to be an alternative business structure. So let me share my screen again. Okay, so there's a committee and they're going to review the applications for these. So you'll have to file an application with the Supreme Court to get set up as an ABS, an alternative business structure. There could be a better name, ABS, too close to BS, alternative business structure. I don't know. It's already in there in the rules and ABS, but something cooler would have been better. So part of what it introduces, I was playing with my highlighter here on my iPad, all the different colors there. So it's a little crazy. So one of the concerns, if non-lawyers are owning a law firm, the concern is that that's going to affect how the lawyer practices law, because now they're going to be driven by profits. If someone else is the owner, they could influence them to do other things. So one of the ways they guard against that is they introduce what's called a compliance lawyer. And then there's some new rules that describe, this 5.1 and 5.3 talks about the duty the compliance lawyer has to supervise everyone. And then also in the ABS, they talk about supervising non-lawyers or maybe non-lawyers in a management type position. So my thoughts about the ABS, I was really excited for this alternative business structure where non-attorneys can own law firms. After everything I learned yesterday, I'm less excited, I'll say. and I'll tell you what I don't like about it. Just I guess I'm just not a fan of licenses in general. The more you have to go get a license and someone else's approval, I don't know if I like that. And let me skip down. I'll show you. It's expensive too. Let's look at the fees. So to be one of these alternative business structures, one, you're going to have to get a license. There's a committee of 11 people. They'll have to approve you. Okay, where's the fee schedule? Here we go. Here it is. So the fee schedule. So if you're a traditional law firm, so what that is, business, ABS's primary business is provision of legal services with non-lawyer economic interest holder. So if you're a regular law firm, but you have non-attorneys as part owners, that's going to be $6,000 for your initial license. And then renewal, you got to renew it every year. Every year, the fee is $3,000 to renew it. So this is what made me less excited. One, the fact that it's going to take a license to get approved. I kind of knew it would take something. I didn't realize there would be a whole board of 11 people, and the fees. That's pretty expensive. So so after you get approved, you're talking an extra $3,000 a month just to operate. Not a month, $3,000 a year to operate that way. So it's because of the fees and the renewals. I don't know. I think you're not going to see many small law firms taking advantage of this. Let me show you what else I don't like. I'm going to skip ahead. This is one of the attachments. Okay, so this is something else that I didn't like. So this is going over, the process to get a license, who can get it, who can't get it. But it comes down to there's going to be a board of 11 people. And I didn't like this. So that Supreme Court committee, they're immune from civil suit. Like I said, that's kind of normal, and all of people, it's kind of like police as well, for better or for worse. When you're a civil servant, you get the immunity. But then on top of that, they're saying the record statements, they're all privileged and protected from civil suits. So what made me nervous, there could be a situation where you're denied your ABS license, and they can just say it's privileged. They can't tell you why you were denied, or they don't have to tell you why you were denied, and then there's no immunity. So maybe I'm making a bigger deal out of that. Maybe it's not a big deal, but I didn't like it. Okay, so that's really all I'll do. That's all I want to say for now on the ABSs. So here's all the rules. So you can have a non-attorney own a law firm. In the CLE yesterday, they kept saying it's going to be no small fee to get that license. It's going to be no small fee to be approved for this alternative business structure. So it'll be interesting to see what happens with this. My initial take is it seems like it's only going to make sense for the bigger companies at this point to come in and operate this way. So Arizona, they're not the first state. Utah actually beat us. Utah passed this a little bit sooner. So they passed, I keep hearing it referred to in Utah as a sandbox, the laws in Utah, where they basically relaxed everything this year, and they're trying it out. But they have a similar alternative, an ABS-like thing where you can be approved as an alternative business structure. So my initial thoughts is that this ABS, since it's such a big deal, where the opportunity might be is if you're one of the early ones out there that gets approved as an alternative business structure in Utah and Arizona, and then you're ready as other states start changing their laws as well. So yesterday they said, one of the speakers, he said there's about 12 or 13 states that have this on their radar that are looking at it right now. I'm a California and Nevada attorney as well. I'm inactive in Nevada right now, but I get the news from all three of those states. California, they were talking about it. I thought it was going to be passed in California this year as well, or something like this, but California voted it down. So we'll see if it comes back to California. Okay, now let's talk about the paraprofessionals. So this new thing, this legal paraprofessional, it's kind of like, so it's a new category that can practice law in Arizona. So the example, it's kind of like a PA, like a physician's assistant or a nurse practitioner, where they can do some of the things, but not all the things. So this legal paraprofessional, basically they have to follow the rules of the bar, of the Arizona State Bar, and they're subject to that jurisdiction and that discipline. The licensing, there's going to be a test which still hasn't been developed yet, as I understand it. But here's the education requirements. So, who possesses the following qualifications: citizen, 21 years old. You can't be denied the admission to practice of law, or disbarred or suspended. You have to have good moral character, comply with the laws of the Supreme Court and the state, pass the examination, and then deemed qualified by the board based on character and fitness. So similar to the process of becoming a lawyer, there's a moral character and fitness test. And then shall possess one of the following combinations of education or experience. So different combinations. So it looks like you can go an associate level degree in paralegal studies, and then it breaks it down further. So there's a family law and civil practice endorsement, a criminal law endorsement, or the administrative law. So there's these different endorsements. So that's part of what the paraprofessionals are allowed to do. They're allowed to practice in these areas. Now, as far as criminal law, paraprofessionals can only practice in the justice courts. So when there's not a loss of liberty at stake. So if someone was facing charges where there's jail time, then they'd have to have an attorney represent them, not a paraprofessional. So for the family law and civil practice, they're going to need some credits in family law, civil procedure, and evidence, legal research, and writing. So I guess if there's paralegal schools that provide this specific education, or I don't know if law schools will start offering paraprofessionals to take these type of classes. But with 3 plus 6, that's 9, plus 3 is 12, plus 3 is 15 hours. So that's roughly a semester of law school. Although this civil procedure, the 6 hours, that's probably a full year. So you have to do one semester and then the next semester later. I think this is cool. I think the paraprofessionals is a good idea. It's good for the public. And that was the motivation behind these rule changes, to bridge that access to justice gap. There's a lot of people that would like legal representation. Either they can't afford it or they don't know how to get an attorney. So I think that this will bridge that gap. Okay, so you can have an associate degree and then those specific hours, or 4 years bachelor degree, and then they still have to have some of these specific classes, which I think is good. And then so after you had the education requirements, pass the exam, and the moral character and fitness portion, then they can practice law as a paraprofessional. So Yeah, it'll be interesting to see how this changes things. Like I said, I think it's good. It's going to bridge that access to justice gap. There's new opportunities for lawyers and law firms. So how they design their law firms, where maybe you could have a paraprofessional as well as attorneys, so you can have some of the tasks be done by paraprofessionals and some by attorneys to help save the cost on clients. Or it's also possible, I think we'll see where companies will have both options, where they have a separate or maybe an affiliate company with a paraprofessional, so they can refer to that option for a client if they want a paraprofessional, or they can have a lawyer through their regular firm. Um, okay, so let's get down. I can show you some of the. Oh, so trust accounts. I hate trust accounts. Not that I hate them; they just make me nervous as an attorney. What a trust account is, that's where if you take a retainer and you bill against it at hourly rates, you put the fees in the trust account until they're earned. A lot of liability with a trust account, so paraprofessionals will also get to experience that. Fee schedule. I mean, not cheap, but not as bad as the ABS, alternative business structure. And I wonder what it costs to take the bar exam these days. It's probably at least, I think I paid around 300 or so when I was taking bar exams. Maybe they're more nowadays. It seemed like it's about $1,000 to take a bar exam by the time everything was all said and done. And that's it. I did Arizona, California, Nevada. That's what I'm basing that off of. Okay, so next, let's get down. Let's look at some of these rules that have changed. So, a lot of these changes, like these evidence rules and things like that, it introduces these new paraprofessionals as well as the ABS. So, a lot of the rule changes are just, practice of law, authorized person to practice law. So unless they're specifically authorized, so that's the new paraprofessionals. Alternative business structure. Man, I like the idea, guys, but better name. ABS, alternative business structure. But I guess that's what we're dealing with. ABS. Okay, so there still is, this unauthorized practice of law, meaning that if you're not a lawyer or a paraprofessional, you shouldn't do these things up here. Give legal opinions, represent a person or entity, prepare a document, any medium on behalf of a specific person or entity, for filing in any court, administrative agency, or tribunal. I feel like practicing law, a lot of people do it, and there's no, attorneys were trained in it. And if we help as attorneys, if we help others engage in the unauthorized practice of law, we have liability. Yeah, right here. So a person or ABS who is not authorized to practice of law must not, provide legal services. Again, but these rules, they really only affect attorneys. So if I, as an attorney, am helping someone practice law or helping someone engage in the unauthorized practice of law, then I have liability towards the bar. But I don't know. It's hard for the bar to control this against other people. Okay, let's look at some of these new rules, or really a lot of rules got deleted is what happened. So this is where it's talking about the committee, the ABS committee. Okay, firm. So they changed the definition there to include ABSs. Okay, what's this one? So this is firm. They changed the definition of firm. And it gets okay. So this is one of the big changes. 1.5 fees. So the old rules lined out a division of fees between lawyers who are not in the same firm may be made only if. So the new rule is two or more firms jointly working on a matter may divide a fee paid by client if the firms disclose to the client in writing how the fee will be divided and how the firms will divide the responsibility. The client agrees in writing, total fee is reasonable. So pretty similar. What we went over. So if there's a flat fee, like a referral type fee, if you're paying someone a referral that was the same amount for every type of lead, then that would not have to be disclosed. But if it's a contingency fee or some sort of percentage fee that that is being shared in, then that would still have to be disclosed to the clients, the amount of the fee. I think there's more opportunities in this fee sharing stuff. The ability to now, so starting next year, January 2021, in Arizona, attorneys can share fees with people that send them clients, basically referral fees. So I see opportunities for working together with financial advisors, realtors, accountants. So people are in similar positions where they're doing kind of a different part of the work. Like I often, in doing the estate planning for clients, they often need a financial advisor or an accountant. So I see opportunities there for fee sharing to help. It's going to help the public get better service. Ultimately, the ability to work between two businesses seamlessly is how I describe a good partnership or a good referral relationship. And let's see, conflict of interest with paraprofessionals. They still have the same rules. They have to follow the same rules, but with the ABSs, alternative business structures, the other owners of the firm, they have to follow the confidentiality rules. It's not attorney-client privilege, but they have a duty to a duty of confidentiality, and then it's up to the compliance attorney in that firm, the compliance attorney in the ABS, to make sure that everything's being followed. Something else kind of interesting, maybe a little scary about the ABSs, is that it doesn't require any lawyers to be the owner. So there could be a situation where, a corporation, you have to disclose the owners of the ABS as well. So it can't be just a corporation. You're gonna have to disclose who the owners are, and but none of them have to be attorneys. So the compliance attorney does not have to be an owner. They just have to be a manager, basically. They just have to have some managerial authority, or I can't remember exactly how they describe it. But a little scary that you don't have to have any attorneys own the firm. Oh, sale of law practice. They changed the rules regarding these a little bit. So I'm somewhat familiar with this, having been a part of transactions like this. It didn't change it a whole lot. Just they get some clarity here that if the client controls their file, but if there's a sale and they don't respond at all after 90 days, then it can go to the new owner. Their file can. So that's cool. There's some more clarity on the sales of law firms. I think we'll be seeing more of those as the older attorneys retire. I see an opportunity there as a younger lawyer, someone that plans to be in this business for a while. This is different too. It used to be that you had to sell. It used to be all or nothing. You could only sell all of your law firm, or but now you can sell pieces of it. All right, I'll go through, show you some of these other things that that caught my attention. Okay, so that's just how it works for the managers. And the responsibility for non-lawyer assistants. 8.3, this is you have to rat out your friend's rule. So you have a duty. See, a lawyer that knows of a legal paraprofessional or certified alternative business structure entity has committed a violation, blah, 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 shall inform the appropriate authority. So as lawyers, we have to rat out other lawyers now if they do anything bad. We have a duty to do that. Also, other paraprofessionals or other ABSs. Is that common in other industries as well, where you have that duty to tell on the others? Is kind of how I put it. It's different memberships at the bar. Create trust accounts. Paraprofessionals get to do those as well now. They're subject to the discipline models or the discipline rules. Okay. Oh, this is interesting. So starting January 2021, a lawyer can say that they concentrate in an area or a specialist, or you just can't say you're a certified specialist. So currently, or until January 2021, lawyers are prohibited from saying that they're specialists unless they were a certified specialist by the state bar. So it was found, other states found this restriction was unconstitutional. So it's finally been removed. Look at this. So this has been removed. It used to be a lawyer shall not give anything of value to a person for recommending the lawyer's service. Off the table. So referral fees, they're legal, ethical now. It's going to change the game next year. Yeah, all this scratched out. Solicitation of clients, this has changed a little bit too. So a lawyer shall not solicit professional employment by live, person to person. It used to be telephone as well. You're prohibited from calling on the phone, soliciting business. Now you can do it if there was always the family members exception, but it added this: if there's a business or professional relationship with a lawyer or law firm, or a person who routinely uses business for the purpose of the type of legal service offered by a lawyer. So lawyers are allowed, or starting January in Arizona, they'll be allowed to solicit by the phone to other businesses. So it could be some opportunities there. Just a new way that you're allowed to talk about law firms and advertise. Now, it wasn't very long ago, 30, 40 years ago, lawyers weren't allowed to advertise at all. So it's helpful to remember that background in the law profession, that it's, that's what we're working with. Let's talk about like prepaid legal stuff is okay. Live person to person does not include chat rooms or text messages. So, so it sounds like it's okay to reach out via text or email. You're not going to get in trouble. It used to be that you had to mark um, advertising when you reached out by letter to clients or to potential clients, but they got rid of that as well. You don't have to mark it as advertising. All right, and that's the main stuff I wanted to go over. Okay, so really exciting stuff. I think it is, at least. It's just the profession's changing, so I'm trying to figure out where it's going to go, how to be a part of it, what's good, what's bad. So my little summary, I would say the ABS, I'm a little hesitant, because it's so hard. It's going to be, I don't know how hard it's going to be yet, but it seems like it's going to be hard. They kept saying it's no small feat. So if anyone on that 11 board doesn't like you for any reason, they could deny your license, and you'll never know because it's all privileged information, and there's immunity from any type of civil suits. So, um, yeah, not super excited about how those go. Or it just seems like too much work. Like you really had to have a large investment from a non-lawyer to make it worth it. At least that's how I'm seeing it now. Paraprofessionals, I think it's cool, this new option of legal service provider. So we'll see how hard that exam is, and once there's more information about it released. But the education requirements and the moral character and fitness requirements, it seems like I feel like that's enough to protect the public, meaning that they're not going to let anyone go into court and represent people. I think that was kind of maybe some of the concerns. It looks like there is enough, requiring some education requirements, moral character and fitness, so to limit who can practice in that area. I think that's going to be a good thing, and I think these, like, deleting a lot of these rules is a good thing as well, like allowing attorneys to pay referral fees and do things like that. It's gonna like I said, I think it's gonna make law like other businesses, other more modern businesses. So ultimately, that should lead to better legal services for the public and a better experience for the attorneys and the people working in those law firms. That's the vision of Mott Legal. That's why I created Mott Legal. That's my passion, to improve the practice of law, to bring it from what it was to what it is going to be. I've seen a lot of changes in my short career already. With the Digital Asset Act allowing it's now possible to plan for what happens to your pictures and videos and your emails. Things are going paperless. You can now do wills electronically. So it's very interesting to me to see, this old profession based in, paper and a lot of history and a lot of, kind of outdated things now be updated. So hope you like this video. If you have any questions, comments, leave them in there. We'll see you next week. So next week I'll be here with Heather Townsend, a financial advisor, for another episode of the Live Pro Network. Take care, everyone.